3, 2, 1, cut.
Hi, welcome to once again a program here on practical tips for protecting public benefits and trusts in order to maximize personal injury settlements here. Today we really have the honor here of having Melissa Baldwin here from Melissa Baldwin Settlements here to co-present with me here. And this is actually a program that we'll be doing for the CAOC convention coming up in November, I think. That's what we're doing here. So in a way, you folks are our test audience. Couple of things as we go through this, because really this is going to be more of an issue spotting program and going through some of the nuances when we're counseling folks about using trust, whether we're using self-settled trust, pooled trust, or as we're going to talk about, sometimes none of the above. So a lot of this, we're going to be covering that subject. The other thing that's really important for folks that are doing this kind of work is that I think it's pretty clear that special needs planning it's a team sport, okay? And it's one of those things where it's the attorney can't do this by themselves, the settlement broker can't do this by themselves, the trustee can't do this by themselves, and the PI attorney here is going to need a lot of assistance. And on top of that, we have clients that are probably about as confused as they can be, because they've just gone through, you know, oftentimes years of either of the whole process of getting to this point. And this is, as I like to say, when I'm the attorney, I am the last attorney here with a little bit of luck. And part of what we're going to do is we're going to take that settlement and work with our team and really do, you know, what's right for our client, eventually our beneficiary. Melissa Baldwin is the owner and principal consultant of Melissa Baldwin Settlements. As a structured settlement consultant and financial advisor for the past 12 years, Melissa specializes in cases involving catastrophic injury, wrongful death, products liability, medical malpractice, workers' compensation, and employment. She works exclusively with plaintiffs and their families, providing them with customized financial plans that offer both flexibility and financial security to meet all of their needs and concerns. In addition to financial solutions, she also assists attorneys and plaintiffs with establishing special needs trusts, minors trusts, Medicare set-asides, QSFs, and evaluating Medi-Cal and SSI eligibility. And this is very common for structured professionals here, is that often they've been working with the attorney and the family, oftentimes for years before we ever work with them. For the past 3 years, Melissa has served as a board member on the National Structured Settlement Association with over 800 members here. And as a board member, she focuses both on education and legislative changes and initiatives, spending much of her time discussing and lobbying on bills being addressed in Washington, D.C. Melissa is the proud business partner here with CAOC here, which is the Consumer Association of California. It's the old part that's which basically is working with what we would call PI attorneys, but in California we don't call them PI attorneys. We call them consumer attorneys here, and a member and supporter of AAJ, CAALA, the San Francisco Trial Lawyers Association, and the Orange County Trial Lawyers Association, and numerous other local trial lawyers associations, bar associations, and all that stuff throughout California and anywhere else, I guess, that she can lend her expertise.
Other states as well, but we'll just leave that aside.
So part of what I'm hoping that you'll get through this, and we'll be taking questions here as later in the program here. Amy is monitoring this presentation as we go, and when we get to the end, we'll be taking some questions. So part of what I want to really get across to you is that, you know, part of it is going through the programs itself, but the other thing that we might want to really touch on is, you know, how to have a good working relationship with your structure broker here, the value of that, and how we can minimize problems as we go. Now, just before we turn this over to Melissa here, let's go through this. This has been approved for 1 unit of MCLE credit by the State Bar of California through the North Bay Housing Coalition here, which is the nonprofit that runs the Golden State Pool Trust. The provider number is 14598. Each section, each of these programs has 3 codes that the viewer would need to record in order to get that credit. So if you do not have the form in front of you, then what I would suggest you do is get out a piece of paper and write down the 3 codes which are embedded in the program, and then to get the proper credit form, and also to, if you're watching this, to get announcements of future programs, what you need to do is email Amy at gspt.org. That's AMY@gspt.org. So anyway, Melissa, I'm looking forward to your presentation here. So let her rip.
Thank you, Steve, for having me. Good morning, everybody. I'm excited to be here. I work with Steve and his team here at Dale Law Firm and another number of other trust attorneys across California. And I have to say, over all the years I've been doing this as a structured settlement consultant, I look at us as kind of the first line of defense or the first line of questioning. We're usually the ones, whether we are already involved in the case or are being brought into the case as it's settling, where we are getting those questions from the attorney, whether it's about public benefits, do we need a trust, don't we need a trust, they have Medicare, they're on Medi-Cal, what do we do? And as everyone knows, we want to make sure that we're not just doing the best for the client, but for attorneys as well, they want to make sure that they're doing the best thing for their client, and also that they're answering all the questions that need to be answered. So the first thing I want to go through, not that I want to read all of the definitions, but I have found over the years that the acronyms that we use between SSI, SSDI, and SSA often get combined together and dovetail together, and they just get lumped into one big category. And they're obviously completely different, as we know. So the first one, just briefly, SSI, supplemental security income. So the main thing to keep in mind with this is it's a means-based test. So this is something where we're not looking at someone's financial history or if they're low income. This is paying benefits to disabled adults or children, someone receiving those benefits at 65 or older without disabilities who meet the financial limits. So basically we're looking at, for them, they can't have any kind of income or qualifying that's over $2,000 in assets per individual or $3,000 per couple. So for example, SSI pays about $771 a month right now per individual, or $1,160 per couple for a household. For SSDI, this one sometimes gets intertwined with SSI. SSDI is completely different. This is an entitlement program. This is something where it's available to someone who has worked and is obviously now disabled due to an injury or otherwise. The key thing here to remember is that if a person's receiving SSDI for the last 2 years, or will be receiving SSDI coming quickly, even with settlement, they will automatically be eligible for Medicare. So too often this factor is overlooked, and it needs to be something that's considered during the settlement to make sure that if they're going to be on Medicare soon, that might be now a Medicare issue that we need to look at while we're settling the case with the client and with the attorney. For the retirement income, the only reason I put this in here, honestly, is because it's another acronym that gets thrown in with SSI, SSDI. I had an attorney call me up last year very concerned about their client, saying that they're just going to lose her SSI benefits. Turns out it was just her regular retirement income that, as we all pay into the system, she started earning when she was age 65. So there's a little confusion there as to what the actual benefits were. So just be really clear, when you're looking at and talking with the clients as to what actual benefit they're receiving per month. So this is the main question I hear all the time. My clients on SSI, SSDI, what can we do to protect their benefits? So as you can see from how that question is worded, those acronyms are often combined. So we need to make sure we're looking at those clearly. So in order to answer that question, we actually need to ask a few more questions. How much they're receiving per month, and make sure we know which program they're actually receiving their benefits from. It's best to spend maybe 10, 15 minutes. Go online, it's the easiest thing to do, to go on and verify through Social Security and be accurate as the exact type of benefits they're receiving before you try and evaluate the client or have the settlement and what we can do moving forward. I wanted to give you a case example this morning. All right, let me back up 1 second here. Let's see. There we go. So beyond verification, so now we have verified the exact type of public benefits they're on. So now what do we do? Well, we need to dive into the case and what the actual client needs specifically. So how much did the case settle for? What net amount is the client actually going to receive? Because often the monetary compensation, the amount they're actually going to receive, will actually sort of dictate the route in some situations that the client's going to go into. What are the client's current needs, future needs, financial, medically, and otherwise? We need to have more of a conversation with the client and possibly their family to get those answers. And then what options can we provide to the client? There's trust and full trust, as Steve will get into more detail a little bit later. Preservation trust, a conservatorship, a structured annuity. But what's going to be the best that's going to help the client, specifically for them and their situation? So in this case example, an attorney, we had this case about 2 years ago, called regarding their client Jessica. Jessica was unfortunately hit by a very large truck while she was crossing a crosswalk on her way to work. And she was in the hospital for over a month, physical therapy for for almost a year. The net amount that she was going to receive was $935,000. However, she fully recovered from her injuries, so in this instance, she's not considered disabled. And I know Steve will get into this a little bit more later, but for this instance, she's not disabled, fully recovered from her injuries. We couldn't utilize a special needs trust to preserve her Social Security income that she was receiving. So when the client and the attorney calls and says, well, what do we do for her? What's the best option? We have to dive a little bit more into, 1 second, notes. Oh, we'll stay on that. I think we got a little more notes going. Anyway, so after spending some time with Jessica and going over her financial concerns, the amount she was currently getting for SSI, and the fact that she was 61 and a half and in a handful of years would be available to have Medicare coverage kicking in pretty soon, she decided that the best option for her was actually to forego and not worry about continuing her SSI eligibility. What she did instead is, from that $935,000, she took $425,000 of it and purchased a modest apartment and paid in full. And from the remainder, we actually purchased a structured settlement annuity for her that would guarantee $2,400 a month for the rest of her life. So in that case, of course, the monthly benefit was well beyond the $771 she was originally receiving from SSI. She now has a place to live that is completely paid for, and the $2,400 a month from the structured annuity would secure her a comfortable living situation for the rest of her life. But that, again, is all case by case. Once we talked with the client, it became clear that SSI was not the concern and the necessity that she once thought it would be after the settlement. The other public benefits that we always talk about and hear about are Medi-Cal and Medicare. So real quickly, let's touch on Medicare first. So most of us know, Medicare provides health coverage for individuals who are over 65, or if they're under 65 and are receiving SSDI. We've mentioned that a few moments ago. And then one of the questions that we hear is, how do I address Medicare in a settlement and make sure that the client is still maintaining the most from their settlement if we have an issue with Medicare? So as most of you know, the standard acceptable go-to, so to speak, for the past 20 years or more, especially when it comes to workers' compensation cases, has been to have a Medicare set-aside allocation report completed and done. And typically that is funded through a structured annuity. This accomplishes three main goals. One, we know we're in CMS compliance because this is something that they have put as far as their rules and requirements that they will accept an MSA being done and approved. even with the structured annuity as far as paying out those annual payments. So it assures that Medicare's interests have been evaluated and will be paid correctly. The payment by using a structured annuity actually decreases the cost of the Medicare set aside, which means that we can put more money back into the pocket of the client. And I'll give you a case example in a second for that. It also ensures that the future payment and coverage for that specific Medicare set aside is for those actual affected, injured body parts and issues that happen due to the accident. A lot of times we've got clients who have a lot of pre-existing conditions or health conditions, and we want to make sure that what they're being treated for and what's being paid for from their settlement is directly through this Medicare set aside, rather than paying for their dialysis or their high blood pressure that they had before that was before they had their accident. Did you want to touch on that?
Okay, and then by the way, just to mention this because this is an issue spotting presentation. We do have an MCLE program with Joe Anderson from Medivest,
right.
our good friend from Medivest. So
he is my go-to for any question I have Medicare related.
And that is mine too. He makes me look smart, and that's good here. So anyway, for those who really want to dig into that, if you look through the MCLE programs, Joe did a terrific job. This is the first of our 3 codes. So if you're doing this for credit, write down on your form, or at least on another piece of paper, here the number 3612. That's 3612. And once again, if you don't have the MCLE credit form, just email Amy at GSPT and she'll make sure that you've got that. So let's learn more.
Okay. So I realize this might be a little bit of an extreme example with our larger dollar figures here, but what I wanted to show you here is this is an actual case we had about 4 or 5 years ago, I want to say. And it was obviously a more catastrophic injury, and the Medicare set aside was quite large because this individual he was a high earning producer as far as his job, and he had many more years ahead of him, where unfortunately now he was not able to work any longer, and he was, this was an issue where he became Medicare eligible because he was on SSDI for about 3 years. So in this case, you can see by how it's itemized, we've got cash to the plaintiffs. Of course, we itemized out there for the attorney fees and costs for this case, and the MSA itself. Now, the MSA, when it came back from the Medicare providing company, it was evaluated well over $1 million just for the set aside. And in that case, we actually did work with Joe at Medivest, coincidentally. And by using the rated ages for our Mr. Plaintiff here, and using the structured annuity, the cost was significantly decreased, well under the $1 million for the MSA. And by doing so, that cost savings, that number you see at the bottom there, that cost savings went back partially into the cash to the plaintiff, but he rolled most of it into the structured annuity, which was that monthly lifetime income payable for 40 years and over. So it's something to consider when having the Medicare set aside done through a structured annuity and through a professional administration, that we were able to keep that cost down a little bit more and have that go back to the client, where really they deserve that money back to them. I have been talking about this and hearing about this, and I'm sure Steve has as well, for the last couple of years. I want to say since, we've heard about a lot, but really since 2017, October coincidentally, there's been notices that have come out from CMS talking about liability MSAs and how, like I said before, the standard go-to for workers' compensation was to have a Medicare set-aside done, and that now that might be the consideration for liability MSAs. So I often get the question from attorneys, in terms of this, do we have to have an MSA when the case is a liability case, not a workers' compensation case? The simple answer is no. There's no steadfast requirement right now, neither for an MSA or by CMS. However, there are many instances, I will say, where having an MSA report done could be the key to a successful settlement for all parties, especially the client. So let me talk about this more in a case example to kind of give you some hard facts. So Ms. Anderson was injured in an auto accident, and she was in her late 60s, already on Medicare. Initially the plaintiff attorney was not considering an MSA report to be done because it was a liability case, and most consumer attorneys fall in the category of, if it's not workers' comp, we don't need to consider a Medicare set-aside. But through the course of the settlement and talks through back and forth, it became evident that the defense was becoming increasingly insistent to cover themselves and their interest in the case, that a Medicare set-aside be done. And also, because of her pre-existing conditions, they thought maybe an MSA would be the answer. Ms. Anderson was on dialysis, she was a cancer survivor, she had high blood pressure, arthritis, she had a whole host of issues, and now she had the shoulder issue and the tears just from the accident that she had. So we had a lot going on as far as medically with her. In speaking in depth with both parties, and considering how much she had going on as far as medically before and after, it was decided that a Medicare set-aside would be the best for this particular case. I suggested working with our MSA provider. One of the bigger concerns, in addition to her pre-existing conditions, was that the case did not settle for what they thought it should be, and the Medicare set-aside that the defense had anticipated was going to be almost the entire amount of the settlement, meaning that Ms. Anderson would walk away with her Medicare taken care of, but no cash, nothing for her injuries, nothing for all that she went through. So we worked with our Medicare provider and had them apportion down the allocation. So in that case, they went through and itemized every single thing for only the body parts for what she was injured, and that actually took down the MSA amount. So if you look at this slide, it's settled for $575,000. We have attorney's fees and costs. The allocation was $109,000 for the MSA, but with the structured annuity, we brought that cost down to just over $88,000. So that gave a cash amount to the client of just over $226,000. Now, if you look at the notation, the defense was estimating the MSA over $200,000. But by working with our provider and apportioning down the MSA as strictly as they did, we were able to make sure that that additional $112,000 went back to the client, rather than going just as a blanket check for Medicare, as it could have done. So let me switch gears for a second here from Medicare, and let's go over to Medi-Cal. This is kind of the trickier, I would say, of the two when it talks to eligibility and benefits. So Medi-Cal is an assistance health coverage program serving low-income individuals, seniors, children in foster care, people who are disabled. Often includes benefits such as receiving in-home support services or those who are in a skilled nursing facility. This is a means-tested program, which basically means, again, it's for lower income, usually more on the poverty level or disabled. And we have asset limitations for this as well, where you cannot have more than $2,000 in assets for yourself, or for up to $3,000 for a couple, which, as you all know, is quite low. So the question I usually get is, my client's going to receive a decent settlement or a large settlement. We don't want them to lose their benefits, so what can we do in this instance? And once again, in order to answer a question, we actually have to ask more questions. We need to make sure that we're getting clear answers before we can just go down a road of a blanket answer. So what we first need to know is, why is your client on Medi-Cal? Are they disabled, were they disabled, or is it due to low income or a poverty issue? The next question is, what is the settlement amount and how much is the net that they're going to receive? Because again, that could sometimes skew us into a different direction depending on if it's a very large settlement or a somewhat lower settlement. So when you look at the two, let's look at two answers for the questions here. Whether they're on Medi-Cal because they're disabled, or B, because they're on Medi-Cal due to a low level of income. So the first one, let me just double check here. Yeah, so in this one we're going to look at a number of options where if they were due to a disability, this is where I work with Steve. I give him a call and say, we have someone who is getting a significant settlement. They're on Medi-Cal. We don't want to lose their benefits. They're disabled now. is a special needs trust or a pooled trust or a conservatorship? What's the best thing for this client? And this is where then I reach out to then the next expert, which would be, of course, Steve as the trust attorney for us for the go-to on that. In this example, this is one we just did 2 years ago, actually. Our client, Mr. Gonzalez, was a young 23-year-old man who was unfortunately permanently injured when a police officer going in excess of 80 miles per hour ran through a red light and T-boned him into his driver door. He was paralyzed, had a quite severe traumatic brain injury along with bone and lacerations and all kinds of other physical issues. Obviously, in this case, he was not recoverable. We have a permanent disability. At that point, then, we were looking to have in-home support services for him as well and his family, who he was going to be cared for at home. So in this case, we're looking right to putting him into a special needs trust. The one thing I wanted to mention in here is, in addition to the special needs trust, which utilized everything that he needs for his family and for his future care, the other thing that we did, and I'm not sure if all of you are familiar with, is we put a part of the amount of money, about $250,000 from the settlement, to establish an ABLE account. And ABLE account, for those of you who aren't familiar, stands for Achieving a Better Life Experience. So this is for people currently who have been disabled before the age of 26. I am happy to say, though, there is a ballot right now to try and extend that to age 41. So I'm crossing my fingers that happens, because there's a lot of people out there that would benefit from that. But given the fact that he was injured at 23, he was in that threshold. And this is basically a tax-exempt threshold account that in this case we used and funded through the structured annuity, placing $10,000 in every year for the next 30 years. And it can pay for things that maybe sometimes trusts don't always pay for or aren't aware of. There's assistive technology where you can touch screens and using things with eye cues and verbal cues. Or even something as simple as, basic living is having the family take him to his favorite movie. They actually have a debit account, and they can use that money to benefit his life and make it as best as they can for him.
And once again, we just, so you know, Melissa, we do lots of programs. We did a program here with Dante Allen from CalAble. Oh. And the really cool thing about ABLE accounts and the difference between that and special needs trusts is, in the special needs trust, the trustee has to scrutinize every distribution. This would give this gentleman some control over at least some of his funds without having to ask his friendly trustee permission to purchase something. So that can be huge.
Yeah, and that's the key right there, really, is to have a little bit more easy access for the smaller things, the smaller purchases that are still maybe daily things for him in his life that makes it easy for him and his family. So the second possible answer to that first question is if the client is on Medi-Cal because of low income. Now, if they are solely due to a poverty level and not disabled, then again, placing funds into a special needs trust or any other kind of financial safeguard is not going to be available for that particular individual. So the best option for the client is usually most often dependent sometimes on how much they're going to receive from their settlement, and of course other things like their health and their age, where they are in their lives. Once you've explained to the client and then the attorney that unfortunately a trust or any other safe harbor is not available, then we kind of have two main options. The first one, as I call it, take the money and run, and the second being a spend down. So let me go back up here. So in the first one, they're going to receive a significant amount of money, somewhere starting maybe around 6 figures, 200,000 or more, but usually it's much higher than that. Everything, of course, is case by case, client by client evaluation. How old they are, and is the money going to be large enough that they can possibly lose their Medi-Cal benefits, but then maybe still pay for supplemental health insurance, for example. So one of the case examples is a client was receiving about $352,000 net to himself. He was 56 years old, single, no one else to take care of, no dependents. And we worked together with him calculating what it would cost to purchase his own health coverage, as well as still paying for his rent and his food and his monthly bills. And after doing all the calculations and working with him, he did decide that he could buy his own health insurance and still pay for his own monthly expenses for the next 20-25 years by taking that full cash settlement and basically foregoing Medi-Cal altogether. So in that situation, taking the cash or taking the money and running, so to speak, did work best for that particular client because the settlement amount was so significant enough he could buy his own health insurance, pay for his bills, and wasn't concerned any longer about losing Medi-Cal. Now, in the second option, this is where the settlement money is not as significant, and in this case, it made more sense to do a spend down. So I'm going to put that list up there for you. So this client was going to receive about $79,000 after fees and costs, and with that amount of money, he still needed his Medi-Cal. It wasn't significant enough as far as the settlement funds to, as the first client, forego Medi-Cal and just take the cash and run. So in this instance, we talked about a possible spend down for him. And when we talked over, he had a lot of debt. His car was on his last leg. So in this instance, we went through and looked at what he could do to itemize spending everything. So for him, he went ahead and prepaid. He bought a new car. He paid some of his rent. He paid off his 4 credit card debts, paid for some extensive dental work that he needed to have done. And after all of that was done, it whittled down his $79,000 to about $1,735, which is, as we know, just under that $2,000 asset threshold for him. The list up here is pretty extensive of the types of things that are the exempt expenditures that the Medi-Cal beneficiary can use to pay off from their settlement. Now, one thing to, of course, keep in mind is that, like anything when it comes to our government, you need to be very, very detailed, very itemized. It's every receipt showing exactly what money was used to pay for what, and again, definitely need to refer back to the tax exempt list there to make sure that you're not spending any money on things that are not going to be covered so that you can maintain the eligibility. And then the other thing to really keep in mind is when it says that there's 30 days in a calendar month to pay for all of those items, it doesn't mean just 30 days. So for example, if the client received the money from the settlement from their attorney on June 20th, they would only have till June 30th to spend down all of that money. That's a really tight time frame to spend all of that money in 10 months, or pardon me, 10 days, and get all of your bills and all of the itemization ready to reporting. So I always suggest to the attorneys, if this is what the option is going to be and the spend down is the right choice for the client and that's what they want to do, if you receive the check in the middle of the month, please wait until the 1st, then give them the check. That way they have the entire 30 days of that month to spend everything down. It gives a lot less stress for the client and a lot easier for them to manage. Of course, we have to report everything, so here's a few ways you can. Of course, we do everything online these days, but some people are old school or even don't have a computer at home. You can do reporting over the phone. I actually suggest that they walk into the local Social Security office. It's just as easy sometimes, and sometimes all the forms aren't easily, at least findable, so to speak, online. So it's easier for them sometimes if they go onto the website or go online and walk in person. So,
and of course, make sure you get a receipt because
yes, of course.
Social Security and Medi-Cal, they make tons of mistakes.
Exactly. So think of it like taxes. You need to make sure that you have all your itemization intact. So I'm going to turn it over to Steve, but I just wanted to wrap up by saying that I'm sure you can tell from everything we just went over that there's no one answer fixes all. There's no black and white answer for anyone, whether they're on SSI or SSDI, Medi-Cal or Medicare. It is kind of a gray area. But if you work with a professional consultant and then someone else, that's another, we have a lot of professionals that we work with in our go-tos, and you have your settlement team, makes things a lot easier in making sure that all the answers to the questions are getting done correctly.
Great. And I do see there are some questions which we're going to answer towards the end. Part of this because we have a ton of stuff to go through. So for the next part of this here, I'm going to kind of build on what Melissa talked about, and feel free to interject if you come up with something here. So we're going to talk about how do you hold the settlements and the different things you might consider. Now we're with our second MCLE code. So our second MCLE code is 5582. So that's 5, 582. So let's plow ahead. We're going to discuss a couple of things. We're going to discuss things like issues that come up commonly, like capacity of the plaintiff here. What kind of entities are we looking at? You know, part of it is, as special needs practitioners, here you don't stick everybody in a trust. It's just a tool, and we have lots of tools in the toolbox, and sometimes the tool is no tool at all. And if that's the right answer, then that's what we do. Management issues, which of course is a huge issue. Long-term planning issues, and also one of the things I like to cover is how do you get into the trust, and the other one that's even harder is how do you get out of the trust if that's the situation. So we're going to talk about that. Now, just a couple of things as we go through this, and as I said, this is an issue spotting presentation. The first thing, you know, in our office at the Golden State Pool Trust or even the Dale Law Firm, when we get a call from somebody, from a PI attorney, or if we get a call from one of our partners like Melissa, one of the first questions we're going to ask is the potential client beneficiary, are they competent here, and are they an adult? And as we're going to go through, that's a critical thing to deal with. So if the answer is no, we're looking at things like guardianships, self-settled trusts under court supervision, and I guess it's so important I put it up there twice. Here, blocked accounts, and we'll talk about what's called a 3611G trust or that sort of thing. That's what we're going to go through. I'm going to go through what I like to call the smorgasbord of options here that the Probate Code give us, and so we'll just walk through the fascinating list of options here. If the answer is that they do have capacity, they still can do a self-settled trust, but it's not going to have to be under court supervision necessarily. They could do a pooled trust. So I think what was number 3 was meant a pooled trust under court supervision. They could go do a spend down. They could just forego the benefits, and there's times when maybe this just isn't worth the hassle here, and so there's all sorts of things. So part of the skill in this, part of the almost fun in this, is, you know, working with the consumer attorney and the client and really getting to know, and oftentimes, once again, this is the value of working with your structured broker, because they've been working with these folks probably from day one, and so they know a lot of the insights about what the client's needs are here and how to put that all together and fine-tune this to make something that works for them. So let's talk about capacity issues. Okay, well, there's nothing more fun than reading code here on an afternoon, but that's exactly what I'm going to do. So if you go to California Probate Code, and I know oftentimes, I just want to tell you, the consumer attorney has probably never opened this part of the code, but when it comes to the settlements, it is the Probate Code that actually determines what you can do and what you can't do. So so part of what it says is a court may not make an order or give a judgment pursuant to all the different things we're going to talk to with an adult who has capacity here, and we'll go through what is capacity without the express consent of the person. So it used to be, before this, every person with a disability had to be treated as if they didn't have capacity, and that changed about 5 years ago. Here. So all these things, if they have capacity, then we don't have to worry about a lot of the things that we have to under court supervision, and we can do something a little bit more streamlined. So what is mental capacity? And I have to tell you, for me, it's kind of like obscenity. You know it when you see it. I don't especially like this definition here, but what it basically says is a person lacks capacity to make a decision unless the person has the ability to communicate the rights, duties, and responsibilities created by or affected by the decision, the probable consequences for the decision maker, and where appropriate, the persons affected by the decision, and the significant risks, benefits, and reasonable alternatives involved in the decision. Now, that is, once again, there are a lot of our clients where they clearly have capacity. There's a lot of our clients who clearly don't have capacity, and then there's a whole ton of our clients where, do they have capacity?
They're in the middle.
They're
There's still
in the
a gray
middle.
area in there. We have that as well.
And I have to tell you, those are the most hazardous cases here. So just as a practice tip as we get into it here, you may have somebody who technically has capacity, and that is the trust that is most likely to go wrong. And it's one of these things, really, I don't know about you, Melissa, as I tell the attorneys I work with, whether I'm doing it as the trustee or the attorney, our goal is to make sure we get a good result for your client, and that you're never going to hear from that client again other than for them to tell you what a great job Melissa and her team did. That's the result that we want.
Absolutely.
But on the other hand, once again, these things are really complex and hard for folks to get through.
As I tell my attorneys, you never want to get that call.
That's it. That's our goal.
That's our goal. Is you never get a call again, other than that something happened or something went wrong.
Yeah. Do we score 100%?
Only happy thank you calls. That's all we want.
No, but our goal is to minimize that. And so, really, for you attorneys that are watching this out there, part of our job is to minimize risk as well as to get a good result here. So, one of the things we're looking for is if the settlement is for the benefit of a minor or an adult with a disability who lacks capacity, then our answer is in Probate Code 3600 through 3612. So we're going to bounce through this pretty quickly. Now, the other thing as we talk about this, as we work out how to make this work, because it does go beyond the code, is who can be the guardian or the trustee, or maybe more like who should be the guardian or the trustee. One of the other issues we're going to talk about is, are they bondable? So I will just tell you, when I get somebody where they insist that, for instance, it might be a birth injury case, very common thing that we deal with, and it may be that mom and dad insist that they want to be the trustee. The first thing I'm going to do is have a bond application run, because as we're going to go through, under court supervision, they're going to have to be bondable, and if they're not bondable, then they're not going to be able to serve as the trustee. Now, we may have them serve as another role, as a trust protector or something like that, but they can't be the trustee. We also are going to have issues about court oversight, which we'll go through, including court accountings. Okay, so under Probate Code 3602, and I'm going to run through these pretty quickly, what it basically says is if there's no guardianship of the estate for a minor, or a conservatorship of the estate for a person with a disability, basically what it says is go to Probate Code 3610. And as we're going to see after we go through all this gobbledygook, we're going to be going to Probate Code 3610. If there is a guardianship of the estate for a minor, or a conservatorship of the estate for a person with a disability, the remaining balance here can still be put into a special needs trust, and all the things we're going to see in 3610 here, we just have to get them in a different way. So I'm going to really, for folks that do have a conservatorship or a guardianship of the estate in place, I'm going to run through that pretty quickly, because in the end, our smorgasbord is 3610, which will lead us to 3611 and 12. So for that, the court making an order may order that all or part of the remaining balance shall be paid to a special needs trust if there is a guardianship or conservatorship. So really, they kind of shortcut this, but it all brings us to the special needs trust. When there isn't, then once again, we're going to go through Probate Code 3610. In a case described in 3610, the court making the order shall, upon application of counsel for the minor or with a disability, or do one of the following things. That a guardian of the estate or conservatorship of the estate could be appointed to hold the funds. Now, and once again, on our smorgasbord of things we can do here, it could just be go into a guardianship or a conservatorship of the estate. Now, the effect of that is that will knock the beneficiary off of any needs-based benefits, but as Melissa already covered, and I will just say all the time, clients don't know what the hell they're on here. And
that's why the attorneys don't usually know. You ask the attorney and they give the information. You get the same information. That's why we do the check.
So you have to trust but verify, just like the old Russian proverb here. Now, if it goes into a conservatorship or a guardianship, that's going to be automatic disqualification of needs-based benefits, things like SSI. It's the Medi-Cal that's usually the most important here, but that is an option. And of course, with a guardianship, unless the person lacks capacity, when they turn 18, the money will be turned over to them. And that's another reason why judges really like structures, because they're not too wild about an 18-year-old getting their hands on that kind of money. It could be deposited in an insured account, here, a single premium payment. This is a blocked account. Now, it could go into a blocked account, and those have their utility, but that means that every time the beneficiary needs something, it means going down to the court, filing something, paying all the fees, and all the fun that goes with it, and it probably is going to mean a loss of their needs-based benefits. It could go into a special needs trust established under Probate Code 3604, which I will be covering in a lot more detail in a minute. If the amount does not exceed $20,000 here, it could be held in however the court feels like doing it that day here, without having to be subject to bond and court accountings and that kind of thing. Now, for those of us that consider ourselves advocates, that's a really low number. That number has been there for some time, and it's probably time to raise that to something a little more rational, maybe $50,000. I don't know when you call a settlement for lack of a better term, a nuisance. But the problem with like a $30,000 trust or account that's going to go through full court supervision is, over time, we're going to spend way more on fees than we are for benefit of our person with a disability. It could go, I don't see this very often, maybe you do, it could go into a Gift to Minors Act account or a California for a Transfers to Minors Act account. I don't see that very often.
I've only had that happen a few times in over 10 years, so yeah. I don't see that really.
So they could, but normally the judge doesn't. Mm-hmm. Or it could be delivered here into a trust. We call these 3611G trusts because that's where it is in the code. So this would be a trust, and as we start talking about alternatives, this would be a trust that has to be revocable by the beneficiary when they turn age 18. And we're going to go through some examples later, but we often use that when we're dealing with a minor when we actually don't know what the hell to do here, and at least this is a good place to park it until we can figure out, like if we're dealing with a 3-year-old, what is their functionality going to be when they turn age 18?
Right, we don't know. That's really know.
So, or the judge could do something else. Okay, so going back to this, think of Probate Code 3611 as your smorgasbord. And out of that smorgasbord, there are all sorts of different things you could do, and you can even mix and match a little bit as time goes on here. So let's talk about Probate Code 3604. And this is true whether we're doing an individual trust or we're doing a pooled trust. We're under the same rules. So this has been one area of growth for the Golden State Pooled Trust, is that I think we're now in 12 jurisdictions here with court monitored trust, and we're slowly moving through the state. So we're taking more and more of these cases here. So if a court makes an order here anywhere within the whole 3600 series that the funds are to be paid to a special needs trust, the terms of the trust are going to be reviewed and approved by the court and shall satisfy the requirements of this section, and the trust is subject to continuing jurisdiction of the court, and that's really key here, and is subject to court supervision to the extent determined by the court. The extent determined by the court is they're going to monitor everything, they're going to monitor every single distribution, and they're going to make sure that everything balances to the penny. And we don't mean close, we mean to the penny, okay? So the special needs trust can be established here, and these are the things you have to be able to show in the petition. Now, some of the courts do it through a full-blown petition, some of them do it through a judicial council form, and then some of the courts do both. So what happens in your court, it just really depends on your court. So the first off is that you have to be disabled. And by the way, generally you have to be disabled. You can't just be somebody on SSI. Now for folks under 65, which means 64 or younger, you can't get on SSI here without being disabled. But on Medi-Cal, you could be on Medi-Cal because you're poor here, or you could be getting it because you're elderly, not because you're disabled. So it has to be an impairment that substantially impairs the individual's ability to provide for their own care and custody and constitutes a substantial handicap. You probably can go by the Social Security rules here as far as who's disabled and who's not, and feel pretty good about this. The next part is that you have to show in the petition that you're likely to have a special need that will not be met without the trust. And I'm going to combine that with number 3, is the money to be paid to the trust does not exceed the amount that appears reasonably necessary to meet the special needs of the minor or the person with the disability. Now, oftentimes you can include in your petition something that just basically says, well, you want to be more articulate than this, but everybody knows that $60,000 isn't enough to take care of this person, here, just give me a break, and that you can make that declaration. When you're dealing with something larger, you're going to have to be a little bit more articulate than that. Now, I'll tell you one of the things I go through, almost always on the larger case, there's going to be an assessment done by a life care planner.
Absolutely.
Which we have been talking a lot about care managers, and they do something similar, but a life care manager is kind of a different animal altogether. Now, Melissa, I don't know if you ever run into this. Part of what the life care planner does is what they do is they assess the needs and basically say, hey, if we had X number of dollars, it's not that we can make Johnny whole, but that this is the proper amount that is really needed for that individual. I can only think of 2 cases in my entire career where the amount of money we actually realized was greater than what was in that life care plan.
Yeah.
And it's magical when you see a larger number, but you don't see that very often.
Typically the life care plans and what we end up settling for, whether it's inclusive of a trust or structure, is less than what the life care plan anticipated or put in there. I will say if you have a life care planner that really knows what they're doing, the benefit that I see from it is certain itemized things that you wouldn't always think about. It's not just the medical and this type of surgery and a new vehicle every 5 years and this type of drug. Sometimes it's something where it's rehabilitative in terms of, well, they're probably going to be a little more cognitive. Their TBI should hopefully get better maybe over time. Maybe they need some skills training on possibly to get a job. Certain things like that. So sometimes there's itemized things in there that gives you talking points to talk to the family about to make sure that the settlement and whatever we put into the trust is going to work the best for them as they're looking into the future as best we all can.
But once again, if the number on the life care plan is larger than what you have, this is really easy to do. Otherwise, you're going to have to get creative. Now, this is really key, especially as we start talking about alternatives and really taking this information and applying it to specific cases here. As with this, I won't read the whole thing, but just like any other self-settled trust, upon the death or earlier termination of the trust, there's a lien for any Medicaid, Medi-Cal, that's used for medical purposes for the entire lifetime of the beneficiary, okay? And so this is something we're really going to focus on. I like to call these Medi-Cal payback trusts. I think it just makes the case better that there is a lien upon this. And California is very aggressive. Their feeling is every expenditure is for a medical expenses, even when clearly it isn't, but that's a battle for another day. So as we go through this, when you're under court supervision, there's a couple of things we're going to look at because once again, these things have a life of their own. And for many of us, not only do we put the trust together, but most attorneys will be involved in doing the court accountings and that kind of thing. For GSPT, it's much the same because these things do have a life to them. And you really, and I think this is part of doing this, that when you put this trust together, part of it is the relationship between the trustee and the person with the disability and the family. It's a really key to this thing working. So now I have a prejudice now, just keep in mind I am the trustee of a pool trust. With very few exceptions, my preference for a court monitored trust is almost always to try to use a professional trustee. It's hard enough to get through this here if you know what you're doing and all that. But on the other hand, my experience has been that an experienced trustee, whether it's a private fiduciary, a corporate trustee, a pool trust, or whatever, somebody who's experienced with the court, here, the accountings are going to go much smoother. And oftentimes, even though the families might think, well, it'd be a lot cheaper not to have that professional trustee, sometimes those are the most expensive trusts at all, because, once again, going through this whole accounting process can be really a bear, even when you know what you're doing. And every time it gets sent back and all that, then the costs go up and the costs go up and the costs go up. And sometimes these accountings, I've seen accountings that have been $12,000, $15,000, $20,000, and once again, that's money that could be better used for the beneficiary. So where do these things go wrong? Oftentimes it is in the choice of the trustee to do this. First thing you do for somebody who insists that they want to consider being the trustee is see if they're bondable. If they're not bondable, that's the end of the discussion. Then you're probably looking at them being a trust protector or something. But the other part of this that you really want to get work with them is is complying with the rules of court oversight. Now, I've had some occasions where my suggestion has been, where the family really wants to do this, my suggestion had been, why don't we use a private fiduciary and at least do 1 or 2 accounting periods? And after it's all done, if you feel like you can drive this truck, then it's not really that difficult during the next accounting period to really have the trustee resign and then have you set in and do that. The other area this can go wrong is the investments that go into the trust. We're going to have something we're going to go through in a minute that's going to go through what the rules are, but there are specific rules about how you can do the investments and what you can't invest in, the largest of which is you cannot use mutual funds in a court-monitored trust, right? And then the other thing dealing with this is making sure that the trustee knows how to comply with the different eligibility rules. Doesn't mean that they have to be an expert, but they need to be able to identify when they have an issue or a problem, rather than taking their best shot at it and getting them knocked off their benefits. Now, what really drives court supervision here, and this is something you want to get across to your consumer or PI attorney that you're working with, what drives this is Rule of Court 7.903. I don't think there are more than 2 days that go by that I don't end up opening Rule of Court 7.903. So basically what it's covering is if we have a trust that's funded by a court order, any trust, it could be a 3611G trust, it could be a special needs trust here, and also if you look at what's required under with guardianships or conservatorships, the rules are much the same. Then once again, we're subject to Rule of Court 7.903. That also means we're going to have continuing jurisdiction of the court for every single distribution, right? Here, and this is a lot of the job of the trustee and working with the attorney is, understanding what's okay and what's not okay and when do we need to go get help. This is not intuitive, and most family members are going to have a hard time with this. They'll use common sense, which can oftentimes doom you to failure. Court supervision under the code means and refers to the court's authority to approve the actions of the trustee. So a lot of what we often are doing if we have what's called an unusual distribution is to ask permission before we do this rather than ask forgiveness here. With that, the order approving and funding the court must provide that the court is subject to continuing jurisdiction here. And with it, not going through everything, but one of the things it has is, for instance, that it prohibits investments by the trustees other than those that are allowed under Probate Code 2574. So most of you, I hope, are literate, so you can look that up yourself here. It requires a person's to be bonded here as in, once again, as required under Probate Code 2320. It requires the trustees to file accounting here, which will be almost always the accounting is the first year and then every other year after that. So those are the periods of time that we really have to focus on. And for smaller trusts, when we go back to that $20,000, the court can The court doesn't have to supervise that unless that they feel they should. Now, we have some courts that have allowed us to maybe go up to $50,000 without court supervision. I just haven't seen much after that. And once again, they're going to put safety first and convenience second. Here is our last code, which is our code MCLE number 3 is 9265. That's 9265. And once again, if you don't have the form, you can email Amy at gspt.org here, and she'll be happy to help you. So what if your client is an adult and does have capacity? Well, if they do, under the Special Needs Fairness Act, they can create their own trust. And up until the Fairness Act, you actually had to get the court or your parents' permission. So now you can actually do it without the parents' permission. Now, the pros are that you're not going to be under court supervision, and therefore you're not going to have a requirement of bond. You're not going to have a court accountings. Now, there's no set price for court accountings here, but you know, they usually are running, anywhere from $1,500 to $2,000, and the sky's the limit after that. I usually estimate about $3,000 a court accounting here, and if we come under that, that's really cool here. So, I mean, that's money that's eating into the funds. But what are the cons? The cons are that the trust will not be under court supervision, and because of that, the chance of this going south is really great. We're going to go back to this. A lot of the advice I give you is because I have a lot of experience doing this. It's the person with marginal capacity where that is the most dangerous case you're going to run into, because it could be really clear the person has capacity. But if this thing goes south, they're going to come back at you and everybody else that's involved in this and go, well, obviously he didn't have capacity, so how could you have let this happen? And so this is one of these things where, once again, and working with your partners, working with your structure partner, working with your PI attorney, and all of that, part of this is that there may be situations where maybe it doesn't have to be under court supervision, but that may be the safest way to go.
I'm going to jump in real quick. I've had a number of instances over the years where the client has capacity, they're settling their own case technically, they're signing the settlement documents, but when I'm having conversations one-on-one or even one-on-one with the attorney, it's clear that they're in that gray area and they're going to need some help. And there are times where we will then go ahead and have them even in another type of a pooled trust or something with Steve, because they are on the fringe and they are right on that cusp, and we know that more likely than not something's going to happen if they're administering their own trust. So if you talk with the client, you talk with the attorney, and real frank, even side conversations, you'll know which clients maybe you need to help gently nudge into a different direction besides doing their own trust without.
I think that's a good point, and this is not really meant as a sales job for GSPT.
No, it's just being honest.
The thing about it is that your pool trust administrator, whether it's GSPT or another trust, they're basically gatekeepers. They're going to review every single distribution, and that will give some level of protection.
Yeah.
So a lot of this, as an attorney, when I'm looking at different options here, part of what I'm looking at, or for what I'm asking myself, is where's this going to go wrong here, and are we likely to have problems down the road? And that may have a lot to do with what I'm going to recommend.
Right.
So once again, if the client is an adult who does have capacity, we just did this, didn't we? So the next thing is, do I really need a trust for my client, or is there an alternative? And I would tell you, the clients, the PI attorney or your structure broker or whoever is bringing this to you, oftentimes they'll come assuming you're going to do a special needs trust. And I have to tell you, when you find an alternative that really works for that particular client, boy, you are a hero in their eyes if it gets a good result without having to go through the whole rigmarole here. So part of this is things that I look at is are the costs, is what is the real value of the benefits. So we're going to go through some examples. So just running through some numbers, and the numbers that Melissa gave were the federal numbers, but I'm going to use the state numbers here because we're talking to Californians.
Yes. I do a lot of federal cases.
There you go. So if they're on SSI, the current rate is $931.72. Or if you calculate this out, it comes to $11,180, especially since I put the comma in the wrong place. Now, it's not that that isn't a consequential amount of money here, but just think of it for yourself. The trustee is going to have sole and absolute discretion, meaning I can deny the most reasonable request under the sun. I wouldn't do it because the next call I'm going to get is from Melissa saying, "What the hell's wrong with you here?" But the fact that I can do that and the loss of control, that is a cost. Now, they may be on a combination of benefits as well. So rule of thumb, if they're getting $951.72, they're getting a combination of benefits. So I just had a case where we're getting like $100 worth of SSI, and the rest of it is SSDI and Medicare and Medi-Cal, and we're jumping through all these hoops for $100 a month. Here, and so part of this that we're looking at is it doesn't really pencil out. For Medi-Cal, you have to look at the Medi-Cal, so you might have the CalFresh, not the CalFresh, the ADA Medi-Cal, you may have the Obamacare, whatever you want to call it here, which will cover basic medical expenses. But if you have greater medical expenses like in-home support services, behavioral health treatments, long-term care, and that kind of thing here, then you're probably looking at disability-related Medi-Cal, which would either be getting the $1 of SSI or the aged and disabled federal poverty level Medi-Cal. Not all Medi-Cal programs are the same. If they're on SSDI, and many of these folks will be, so they may be on getting SSDI themselves, they may be on childhood disability benefits and that kind of thing, and they will get Medicare, they're going to be Medi. Now, if we look at the value of the Medi-Cal in a case where we don't have a lot of unusual expenses, the Medi-Cal only pays the copay. That's all it's doing here. But it could also be covering attendant care, which would be the IHSS and the behavioral health needs. So oftentimes when we're looking at trying to decide what is the value of the benefits we're protecting, we may be looking at getting a consultation or working with somebody. We often use national care advisors to just tell us what is the value of those benefits. They're not always apparent. And there's a lot of cases where if it's just paying the copay, that could be just a couple $100 a month. It doesn't really make a whole lot of sense to go through this rigmarole for a couple $100 a month.
And I think that's a really key point because a lot of attorneys hear SSI or public benefits and they assume we have to do some sort of trust or have to do some sort of preservation of the benefits. And if you get the real down and dirty answer where it's only the copay or $100 a month, as Steve just said, then going through the effort and the expense of a trust then maybe is not something that needs to be done.
So plowing through the last of this, because I do see we have questions coming up, so I'm going to leave time for that. And we will be ending exactly at 1 o'clock today. So a couple of considerations here as we go through this, and then I'm going to go through some examples. Special needs trusts are relatively easy to create, but they're really hard to unwind. And so what I want to do is I want to go through a couple of case studies where that has come up. And so sometimes the skill in this is not only planning getting you into the trust, it's planning on how to get you out of the trust. Remember, there's a Medi-Cal lien upon the death of the beneficiary, but also for earlier termination. So let's go through a couple of cases real quick. Here, John has a settlement of $800,000, which left him paraplegic and initially unable to work. The settlement was placed in a self-settled trust, which preserved his eligibility not only for SSI and Medi-Cal, but also for in-home support services, which pays his attendant care. Despite his injuries, John, after much vocational training, with his physical therapy, was able to become self-supporting and eventually was able to get private health insurance and was no longer dependent on his SSI, Medi-Cal, or in-home support services. There's this a thing we call in the business when we're trying to transition somebody off of needs-based benefits into private, the private world is the cliff, right? So you can go so far and work on Medi-Cal, but eventually you go off the cliff, and so you start losing your in-home support services. So the key is to give them the supports they need so they can get to the point where they can pay for all these services themselves. So as an alternative, if the funds were used to purchase a home for him, which is an exempt resource, then the trust, the funds would not be terminated, the funds would be expended and or exhausted, and we didn't terminate the trust. So sometimes when we have somebody like John, and I always put myself in this place, and here's a question for you. How many of you would like to be your own client? How many of you would like to be on SSI? For myself, I would not like to be on SSI. I like to control my things to the extent that my wife allows me here, but I like to have some control over my things. And one thing about this, in John's situation, here's a guy who lost control of his legs, he lost control of his life, and he's lost control of his funds. And if we can bring this character some dignity and get him back on track and have him fully in control of his life, that would be great. So in this case, what we might be planning is, we're going to do the special needs trust, we're going to get the in-home support services, we're going to get that together. But the other thing is, John, when you get to the point where you can be self-supporting, then what we're going to do is use these funds to purchase an exempt resource or that kind of thing. We cannot just merely unwind the trust. Here we have and this is another thing that comes up with children. And I will tell you, monitoring this, you may think where these kids are going, but you don't know until they get there. So you may have somebody who's catastrophically injured, and you think they're never going to be able to support themselves, so just to double cross you, they turn around and do it anyway, which of course is what we want to do. So Beth was injured from birth from a medical malpractice here during labor and has serious physical injuries. Despite her injuries, she's cognitively fine. It's unlikely that she'll qualify for needs-based benefits until she turns 18 because her parents have substantial assets. So in this case, there's a thing called deeming, and so often it's really rare that we get somebody on SSI here, because for that, the parents have to be crazy poor to make that work. Here. Now, she may be qualified, and you'd want to work on this, she may be qualified for Medi-Cal under a different waiver, and that may change what we decide to do. It's unclear how important it will be later for her to qualify for SSI and Medi-Cal. So rather than place the funds in a special needs trust initially, we would either place it in a guardianship of the estate, or we might put it into one of these 3611G trust things we had talked about here. And then at some point before she turns 18, then we'd make a decision, and then we would go back to the court, probably during the accounting period. And then if she needed a self-settled trust, we would do it then. You can always go from a guardianship to a special needs trust. It's really problematic going back the other direction. Last one real quick. Here is Robert was the victim, and by the way, we should not call them victims. So I know somebody who's going to read this and tell me I shouldn't have done that. Here of an automobile accident and left him with a traumatic brain injury. Here, while Robert has capacity to receive the funds, he and his family recognize that there's going to be substantial challenges, and he'd like the money managed by a professional trustee. Now, this may be in a situation we get lots of these where he technically has capacity, so we don't have to be under court supervision, but and just because he has a TBI, all that tells us is he has a TBI. But let's just assume in this situation, he's pretty challenged here. It's hoped the settlement he received will be adequate to provide for his needs for the rest of his life, but it's unclear what his future will be. So Robert has his funds placed in what's called the Settlement Preservation Trust. These are really becoming more and more popular, which is managed by a professional trustee. We do a lot of these things here. Part of with the Settlement Preservation Trust, under the terms of the trust, the trustee has the option to convert it into a self-settled trust if we need it at a later date. But the other part of that is we're going to have at least the ability to have that under supervision of a professional. And we go back to this. This is good for Robert here because there's all sorts of crazy things that happen with this money when it's not supervised. In this situation, I probably could go to Robert. And what's the chance that Robert's going to have that money long-term?
Right.
He's going to have a lot of friends that are going to show up.
A lot of friends, a lot of cousins that just you've never seen before that
who
come
have
out to say hello.
great ideas.
Yes, I call it the lottery syndrome. Everyone's your friend
Yeah.
once this happens.
So let's go through as many questions as we can in the next 15 minutes here. Now one thing is I can actually see. So what I'm going to do is we're going to break protocol and we're going to go through this. Okay, so let's start with a hardball first. Here, if I can read this. The first question was, well, I'm going to go to the second question because for some reason, oh, there we go. So, Gary, we won't use last names, would be interested to understand how the present value of the projected life benefits of approximately $3 million in the example of the comp here was for a $1.8 million cost.
Yeah, so in that one, that goes back to two things. The first one is rated ages. So when we have someone like myself who's in her 40s, we'll just give you a round number, and I'm injured, and because of the injuries I sustained and possibly pre-existing conditions, maybe I'm a smoker, maybe I had cancer, maybe I have high blood pressure, and I've got pre-existing medical issues. We send those medicals to the underwriters and they look at it and say, well, Melissa's in her 40s, but really health-wise, she looks like someone who's actually more about 56 years old. And that just shaved off over 10 years of my technical life expectancy. And when we price out and quote a structured settlement annuity that's going to pay either for that annual Medicare stream every year or a structure in general that's going to have a lifetime component, we're looking at paying for benefits only for rather than from the 40s into age 81 as a life expectancy. Instead, we're looking at paying from the mid-50s and those 10 less years from age 50s into the early 80s. That decrease in life expectancy gives us a cost advantage because the underwriters are basically saying this person's not going to live as long as they're supposed to, and therefore it's a little bit cheaper to be just, crude, to be honest, cheaper to pay for all of those future care because they potentially will not live as long. On the flip side, if they live into their 100, we're paying for them for their lifetime care regardless from the annuity. But that's how we get that cost advantage, is that rated age component.
Okay, here's one from one of my favorite fiduciaries in Southern California. You know who you are here.
Uh-oh.
Our entertainment, well, they're all my favorite. And you're my favorite structure broker, too, and I'm sure I'm your favorite attorney.
Yes, absolutely.
Depending on who you're in front of,
right?
Of course, right. So our entertainment expenses eligible for ABLE accounts. I don't have the full list in front of me, so I'm going to give you kind of a double answer here. When you're dealing with ABLE expenses, there are what are called qualified disability expenses, and so there's a long list of things that are okay, and there are things that are not on the list, like food. I don't believe entertainment is. Now, what most of the ABLE programs have actually latched onto is some dictum that was used in describing the regs that says, hey, a QDE is anything that enhances their quality of life. And some folks said, I really like that. We're going to add that to the list.
Going to Starbucks.
And that sort of thing.
Right.
Now, once again, is that a proper QDE or not? I'm not sure that it is proper. I think he would, and this is not the way we're supposed to operate, I think he would get away with it here, but that isn't something that
not advisable, but
And the thing that we deal with when we're, and this is one of the reasons where I really like your solution here, and the one that you had, where obviously you must have had a separate amount of funds that was going straight to the structure.
Yes.
Here
and payable to the trust.
And a separate one to the trust.
Feeding into the special needs trust.
And we're seeing that all the time.
Yeah.
If I were the beneficiary of that ABLE account, I would use it for entertainment. I wouldn't give a second thought to it. We as fiduciaries are held to a higher standard, right. So maybe you would okay it, maybe you wouldn't, but right. You probably should.
This is not advice, but I will say yes. going to the movies, getting his favorite Frappuccino at Starbucks, things like that have been used from that ABLE account. I cannot speak, neither conceive, I don't think, as to, if that crosses a threshold or not. But it has been done. I'm not advising of it. But.
And the other thing as we do this, that is that for the beneficiary of the ABLE account, what they're risking is an almost laughable tax hit.
Right, because
it's so laughable. I don't know.
It's so minuscule.
It borders on ridiculous.
Right.
But we go back to this as fiduciaries, we're at a higher standard. Once again, depending on the situation and depending on whether we're on court supervision or that kind of thing, oftentimes we do, because Social Security says that Medicaid, Medi-Cal follows the same thing, is they're not supposed to review the expenditures. So once again, we're a little looser with ABLE accounts.
Absolutely.
My preference is your solution. We have somebody who buys a lot of medicine, marijuana. Okay, now you might find this shocking. I don't have a problem with my beneficiaries if it's therapeutic buying medicine, but I'm not too thrilled about that showing up on my court accountings here, or me being in the line of the funds. So if they have the funds that are going into their ABLE account and they're going out and buying their medicine, I don't have a problem with that.
Because there is no reporting in that instance for ABLE, so we're good.
Okay. Can you address vacation experience? What are the current POMs? Thoughts on that? We're going through. We probably have 3 reviews a week by Social Security of our beneficiaries. Here we pay a lot of vacation expenses, and we have not had a problem with that at all. The only vacation expenses we run into is if we're paying for attended care, and there are specific POMs on that. Here, and so really there's kind of a reasonable standard there. So for instance, and this is where we'll often get a care manager's assessment, even when it's absolutely clear what the need is. If we have a child with a severe disability, then we can't take a family as companions, but we can't but we can have them pay for as attendants. Mm-hmm. And then the other issue with it is if when you have somebody who needs 24-hour care, then you probably could justify 2, maybe 3 people, depending on the situation. Mm-hmm. And in that case, we're probably going to paper that poor thing to death. And this is another area that if we have a settlement coming in, and let's face it, and I know the person asking this isn't very far from there, they all want to go to Disneyland.
Oh, that was going to be my example.
It's required.
It is, and in the one we had in the past, we had a severe TBI, but at that point they were nonverbal, but loved Disneyland. He was 20 years old, and so in that case, the trust paid, of course, for all, and they were out of state at that point, to fly into Disneyland, all the expenses for him and his mother, who was his primary caregiver. Dad and sister had to pay for themselves. So that's just one, small little example of how you can, but you can't take, your family of 12.
So this is where we would work as a team, and sometimes it's trying to work out how to meet their requests. And once again, going to Disneyland, that's something typical children do, something that we should allow our folks. Sometimes it's managing expectations, because no, you can't take out all 12 family members and have them feed off the trust. That ain't going to happen.
Right, that's not just quick dialogue you have to have. Yes, you can, but...
And then work through that, and then we might even want to include that as an expense that's already been pre-granted as we're going through the petitioning process. Once again, when we have what we would call unusual distributions, better to ask permission than ask forgiveness here, and so that's something we might want to do off the bat here.
Absolutely.
Okay, what else do we have? What are the criteria for a trustee to be bondable for a special needs trust?
I was going to ask you that because I know a lot of my attorneys I work with, when I ask that question and I give the details of what bondable means, they kind of look at me as like a deer in headlights. Many don't know, understandably, because it's not their main area of expertise, that the trustee has to be bondable. So basically you have to have enough assets that if for some reason the amount of funds in the trust
that you have enough, that if something were to happen, that you have enough funds to reimburse the trust.
Right.
Maybe equity in the house and that kind of thing. Now here's something, once again, that may, and we could do a whole thing on structures themselves. You may have a $2 million settlement. Maybe you're the family member who wants to be the trustee has $1 million in assets. How might we reduce the amount of that settlement down to $1 million here?
There. We could do the structure and have that actually equate to the million, but yet the payments are ballooning into the trust.
So that may have something to do with it. And we've had times where there's many reasons for doing a structure. There's many reasons for not doing a structure. It
Absolutely.
really depends on the situation.
Always case by case.
Here, but that sometimes we have had situations where the family really insisted they wanted to be the trustee and that kind of thing, and that is one way we can actually bring down the amount that has to be bonded.
Right.
So,
the other thing I will say quickly about bondability is that a lot of the family members that I work with that insist they want to be the trustee are in a lower poverty income, and they just can't out, and it really it somewhat seems. Well, they're just unhappy to be frank. But then we usually switch gears, and rather than talk about the bondability, we talk about all of the court approval and all of all the times you have to go into court and have all of the itemization and all your accountability, and that usually really rings home with them that it's not something they want to have to be responsible for. So if you have a client that is sensitive of their financial situation and are possibly upset that they're not bondable because they have to have the $1 million that's going into the trust, then switch gears and talk about all that's involved with reporting and the accounting, and it can be quite overwhelming, and that they want to make sure that they're doing the best for their son or their daughter or their family member, and that usually kind of brings them back into the fold.
So in the last 4 minutes we have before we call time, and I know, and by the way, if you're on the Bay Bridge, you might keep an eye out because we have somebody who has to be in San Francisco in an hour.
I'm meeting with the plaintiff.
You might want to stay out of her way. But going back to this, if we were really doing the proper panel, the person that we probably should have here is the fiduciary. So we just go back to this. For those of you that are watching this that are consumer attorneys, special needs attorneys, and that kind of thing, I have to tell you, your relationship, a lot of it is relationships with your partners, relationships with, your trustee, because once again, we often have a symbiotic relationship. And this is whether you're using the Golden State Pool Trust or a private fiduciary or a corporate trustee. There's no single answer for everyone. The structure professional, they are a key member of the team. And I will tell you, in most cases, they have been involved in this case from day one. They know a lot about the dynamics of the family and that kind of thing, and they can give a lot of guidance. You really want to work with, once again, your investment professionals and that kind of thing. And with that, the attorney really, in a way, in working this to get, is the special needs attorney. Really, the job is to work with your different partners, really sit down and analyze the situation here, look at our different tools and our different factors, not just present situations, but future situations, and do our best to find the right vehicle to put it in, whether it's a guardianship, conservatorship, 3611G trust, special needs trust, pool trust, whatever it is, to find the right vehicle for that, and really work as a team for the benefit of our beneficiaries. Yeah. That is the way to run a successful practice, and that is the way to please your referral sources, the PI attorney and the consumer attorney, who's putting a lot of faith in us to do what's right for the client that they've worked with. And they really do care about their clients here, and they really like it when somebody spends their time with this and really can fit this to the specific situation.
And I will say that, as for the attorneys out there or the other fiduciaries that are looking and working up these cases, as soon as you hear those phrases, those acronyms, when you hear SSI, SSDI, Medi-Cal, Medicare, if there's a capacity issue, a physical disability issue, any of those things, and you possibly are thinking of trust, any of those things come into play, I just highly recommend, and I know Steve agrees as well, to please get us involved early, or any of the professionals you work with, so that we can help blend the settlement to the best for what's best for the client. Sticking it on the back burner, or whether it's the public benefits, or maybe we'll see about a trust, or maybe we'll figure out Medi-Cal later. And when you're trying to wrap up a case and get things settled, and defense wants to hurry things up, it's just going to add too much to your plate and a lot of stress. So the sooner you can get us involved and ask questions so we can help guide you in the best direction and the client in the best direction, we'll just make things so much easier when it comes to settlement.
Well, Melissa, we have come up to 1 o'clock here, so we've run out of time. For those of you that are watching this, remember that this, and DJ, if you could put this up here, is we may change this depending on how much time we have in this. This will be approved for at least 1 unit of MCLE credit. If you're looking to apply for credit, please email amy@gspt.org. And we will be announcing our next programs coming up in the very near future. For those of you that are going to the Stetson program here, please say hi. And with that, I want to thank you for watching, and happy advocating.
Thank you, everyone.